if you've been following this channel for a while, you know all about everything that's happening in the ACC with Florida State and Clemson. We have dueling lawsuits. We have 4 different lawsuits in 3 different states. It's a lot to try and decipher and keep together. And I am no legal expert, so I'm bringing in a legal expert in Doug Rohan from Rohan Law. What is your legal background, just for everybody to know before we get going?
Well, thank you very much for having me on the show. It's a pleasure to be here and meeting you and talking with your viewers. Of course, I'll stalk the comments later and answer any questions that come on after the show as well. But I've got my own practice in Atlanta, Georgia. I've been in practice for 20 years. I've had my own firm for over 10 years, and we specialize in work accidents and criminal defense. And that's everything from a speeding ticket up through murder. We've got a great criminal defense team with multiple lawyers that can handle any type of case. And then work accidents are particularly difficult set of circumstances when somebody's been hurt at work and they lose their income. There are laws that are designed to provide them with benefits, but the reality is that the insurance company very rarely does what they're supposed to do. So we're here to punch them in the throat when it becomes necessary. We say we want to be your best friends on your worst day. I hope nobody ever needs my services. But unfortunately, I get a dozen to 2 dozen calls every day of somebody that woke up and didn't realize that they needed to call my office. So if you're ever in Atlanta, if you're in the state of Georgia, if you have any friends that need anything, please don't hesitate to give us a call. But for right now, really all I would ask of your viewers and followers is to check us out on X or Twitter, whatever they're calling it these days, at Rohan Law PC. And that way you can stay informed with us and follow along with our adventures.
How about just layman's terms? What is the lawsuit between Florida State and the ACC from both sides? I guess both of those cases. How could you best lay out what is happening there in the most basic of terms?
Well, thank you, John, very much for having me on here. I have been following your show and I've appreciated what you've been sharing with your viewers. It really comes down to a lot of what you said. You were correct in a lot of your assessment that Florida State is upset, Florida State is frustrated, and Florida State is doing whatever it can to try to get out of the ACC for the most reasonable price possible. So Florida State announced, as was required by Florida laws, that there would be an emergency Board of Trustees meeting on December 22nd. And in response to that announcement of a Board of Trustees meeting, the ACC went ahead and filed in Mecklenburg County their request for declaratory judgment action. Now, what they were trying to say in North Carolina by the ACC is that the grant of rights is enforceable and Florida State is subject to the grant of rights. The following morning, as was expected, the Board of Trustees for Florida State did agree to go ahead and move forward with filing a lawsuit, which of course they did already have prepared and drafted up, and I'm sure shared copies of it, and did what was to be expected, was to file in Tallahassee in Leon County their motion for declaratory judgment. So both of these cases are just asking the court to define what the contractual agreement is. Now, in response to the ACC rushing to the courthouse, having this race to the courthouse to try to get priority over Florida State did file an amended complaint in Leon County. And that's where the gloves really started to come off. That's where we started talking about John Swafford, and that's where we started talking about all of the other secondary issues that are related to this. In response, of course, the ACC likewise filed their amended complaint in Mecklenburg County, addressing why Florida State was breaching its fiduciary duty to the conference and all the bad things that Florida State was doing. This is effectively a business divorce. And when you take a step back, for those who are critical of Florida State, you have to understand the leadership of Florida State did the math. And Vanderbilt was going to be getting $30 to $40 million per year more than Florida State's athletic program starting in 2026. And that was something that was just unsustainable. You now throw in what we know since then about the playoff agreements and those additional payouts that are also now sliding scale in favor of the Power Two. And that number really balloons up closer to 50 or maybe $60 million per year. So yes, Florida State signed an agreement. Yes, Florida State signed a contract. But the reality is that the ACC did not do what it was obligated to do. In the grant of rights situation, Florida State and all the other members gave their rights to the ACC to therefore manage and work through the best deal possible. And so, what this litigation ultimately boils down to is an accusation that the ACC failed in its fiduciary duty to exceed the value that Florida State could have gotten on its own, to maximize the value. And that's where all the Swofford stuff and mudslinging comes in. And we can get into those details further on.
Yeah, on that front, I mean, as an outsider and somebody without legal experience, I start looking at it and it's like, man, digging this deep on some of that stuff, like John Swofford and nepotism, it started to feel to me like, okay, this would seem to be like trying to get them going in a bunch of different directions and get tired of this and just be like, look, we might as well just settle, right? Like we don't want to deal with all of this stuff going on. Is that from a legal standpoint, does that seem to be what the strategy is here and where this may be ultimately headed because of that is a settlement?
That's a very valid criticism, and it is the reality of what Florida State is trying to accomplish. The status quo, if Florida State loses on all of its counts, we are stuck in the ACC until 2036. We don't owe the ACC $500 million. We don't pay them a lump sum, but we just don't get to leave. Well, if we don't fight for our freedom, if Florida State doesn't try to pressure the ACC into some kind of an agreement, then we're still stuck in the ACC until 2036. So the status quo, that's why I say not doing anything was untenable. Not doing anything put in jeopardy the existence of Florida State as a national power. So yes, these salacious details, which are not without merit and may be out of time, it may be beyond the statute of limitations, that's a different issue. But the allegations are examples that Florida State is using to show the judge evidence that the ACC has not operated on the up and up. They have not worked to the benefit of its members. In fact, they have worked contrary to the benefit of its members. So while those specific points may seem gross and may seem just like mudslinging, they're data points to give the judge reason to find just one cause of action in FSU's favor. Florida State doesn't need to win all the arguments. They just need to win one argument.
Yeah. What to you is the most compelling piece of it, the Florida State argument on this side?
Well, the first hurdle, let's talk about really where we are procedurally. We're still fighting over whether this is going to be a North Carolina case or a Florida case. And that's where Judge Cooper's order came out yesterday. Those are those most recent tweets. If you do follow me at Rohan Law PC, there's no question a double null judge in Florida, Leon County, is going to lean in favor of Florida State. And there's no question that a ACC graduate from, I believe it's Duke University, and Judge Bledsoe has a very likely chance of rooting and being in favor of the ACC. Both judges have demonstrated some impartiality, and I believe both judges are capable of ruling on the merits, but both teams want home field advantage. Doesn't mean you win if you have home field advantage, but it certainly helps your chances. So in North Carolina, Judge Bledsoe threw out the North ACC allegation that Florida State breached a fiduciary duty to the conference. They said there's no way that anything under the law substantiates any duty that Florida State owed the ACC other than what's in the contract, and we'll talk about that. And similarly, the Florida State judge, Judge Cooper in Leon County, dismissed in a somewhat embarrassing fashion the entire complaint with authority for Florida State to refile. Now, there is what we call in business a problemtunity. Yes, it's a problem that your complaint was dismissed, but this now comes after the Clemson lawsuit has started up. So Florida State gets the opportunity to strip down their entire argument to the bare bones and build it back up. They can file a completely new complaint with new allegations, and that's what I expect to see in the next few weeks.
You jogged my memory on something that I saw somebody, I think it was maybe even on Twitter today, or maybe it was Matt Baker from the Tampa Bay Times who's been covering this quite a bit. But since we have like two different sets of lawsuits going on here, like what happens in a world where we get to like a different ruling in both cases? And you now got the ACC against Clemson, it goes one way, Florida State against the ACC, it goes the other way. Like how convoluted could that ultimately get?
It could get very sloppy and very messy. And in fact, that's one reason why both judges have reminded all the parties this case should settle. And it likely will settle. I would put the chances of settlement at like 98%. We see in practice every day. My background is in work accidents and criminal defense. And the reality is that there are very few cases that go to trial. The only cases that go to trial are cases that have to be tried. My client needs to have back surgery. The insurance company doesn't want to approve it. We can't settle because it doesn't matter how much money is offered. We need the doctor to perform the back surgery. That's an example of a case that has to go to trial. Here, we're dealing with a contract. Contract is about money. Money can absolutely be settled one way or the other. Now, both parties might be unhappy, and frankly, typically in settlement and in mediations, neither party is fully satisfied, but that's just the sign of a reasonable deal. So that's the question: is what's the timing and when? But to get to your other answer, or your other question, that's one of the big unknowns. As far as I can tell in my research, because again, I'll remind your viewers, we talked about this off air. I don't do contract law. I'm not a media rights expert. I've been learning this as we go along. I am an attorney with my own practice. I am an FSU fan. These are both of my loves together, and I want to break down what's happening for other FSU fans and now a broader national audience as to what's actually happening. As best as I can tell, there is the chance that neither court gives up the right to try this case, that both cases could go to an ultimate conclusion. And then we have the United States Constitution that's going to dictate that whoever reaches a conclusion first must receive full faith and credit by the other state. So if a state court decision occurs in one state, the other state is obligated to accept that result. So that's why there's been so many questions about the pace at which these cases are moving, because if both cases are going to move forward, that's the next question: is, okay, who can finish first?
Yeah, and speaking of pace, what is a reasonable timeline to get to settlements here? Like, I know this is a little unprecedented. We've never seen like a conference and a school suing each other. But best you can tell, like, what would be a reasonable amount of time to expect this to all finish up in?
Well, one analogy that we can draw upon is the Maryland departure from the ACC. So that happened at the start of all of the grant of rights and the increase of the exit fee. But Maryland was the only member that said, you know what, I don't like these new rules. I don't like these new buyout provisions. I'm out. It took them 18 months to reach a settlement in 2012 and 2013. Now, we're in a more aggressive media news cycle. Conference realignment is moving a little bit faster now. We also have the very important pressure point of ESPN with a February 2025 decision timeframe. So I believe personally that August 15th is a very important date. So there's a couple of important dates. I'll give you the conspiracy theorist version after I give you my version. But August 15th is the date by which a member needs to announce their departure from the conference. So even if there is some kind of agreement or framework, I don't believe there will be an announcement earlier than August 16th. And the reason why is because the ACC wants another year of FSU broadcast rights. And frankly, Florida State could use another year to find a landing place. Not that they don't already have a handshake agreement somewhere, but it will provide a more orderly transition to their new conference. One of the secondary issues that a lot of people don't realize is Florida State's going under a massive stadium renovation. And the question is, will that be ready in time for the 2025 season? We know the 2024 season is going to be construction. So they don't want to open up, against a new conference partner, especially a marquee game, if they're still tidying up some construction overhaul there. So that's why I think personally nothing happens before August 16th. There are some who are looking at June 30th as an important date, because July 1st is when SMU joins as a member. And then in August, we have two more members, Cal and Stanford joining. So some are thinking that there is this nuclear option where 7 members of the conference just vote to dissolve the conference altogether, and that would have to happen by June 30th. I don't know that we're on a time frame for something that dramatic. I really think a mutual agreement for some kind of settlement in August or shortly thereafter is probably the best bet, certainly before the February deadline of the ESPN to decide what they want to do.